Yeah, dear all, this is Tirupati Reddy Aram Reddy, Active Secretary at American Telugu Association. We are all familiar that ATA got established 3 decades ago, and the main purpose of this organization is to assist and promote literacy, cultural, educational, social, economic, health, and community activities of the Telugu origin people in US. It's our practice to conduct this educational, health, and immigration and other any social related seminars. As a part of this today, we are conducting immigration webinar by our legal committee chair, Madhurima Boyapati Paturi Garu, and Sunila Bali Garu will be the moderator for this webinar. The purpose of this webinar is to understand the immigration related issues and how to resolve the same. I look forward to seeing you all, hoping a productive meeting. If you have any questions or concerns, please do not hesitate to reach out our legal committee chair, Madhurima Garu. Thank you very much for ATA President Madhu Vamineni Garu for giving me this opportunity to give introduction about this webinar. And also special thanks to Anil Bodireddy Garu, Board of Trustees, and other key persons behind this webinar. Yeah, I hope this webinar going to be a great, event, for today. Thank you. This is Tirupati Reddy.
Thank you, Dr. Aram Reddy Garu. So, as we just beginning with the immigration webinar, I want to introduce my good friend Sunila here, and we both practice immigration law. I practice from Orlando, Paturi Law, and Sunila works with the Somireddy Law Group. And we both, with our experience and expertise, we just want to discuss with a few hot topics. And as mostly are aware of, the H1B is the most hottest topic, and especially with the H1B registrations. So as we know that in the March, there was H1B registration period started in the March and end by the end of the March. And this year, the recorded number of over 750,000 applications for the registration received, which is the highest. Obviously, out of that, they have to only choose 85,000, but USCIS end up doing 110,000 applications, which is still 14 point something percentage. And a lot of those registrations or multiple registrations, that's the way the biggest and the hottest topic is going, So why there is more multiple registration after given the regulation very clearly about the attestation. So what is the consequences of it? How is the USCIS is taking that one? And what is our experience dealing with the multiple beneficiaries last year? These are the important topics we're going to be talking. And if you do have any questions regarding to this, keep posting in the whatever the channel you're looking into it, and we'll take those questions as it comes. Well, Sunila, I know you can jump in anytime. So it's going to be more conversational here. And do you want to say anything before we start on this conversation?
Absolutely. First and foremost, well, thank you for having me. Madhurima, it's always nice to, meet you, be with you, talk to you, but like being on this panel is special. Sorry. So thank you for the opportunity again. As you just pointed out, I mean, everywhere we go, everything we do these days, all that we hear about is, H1B, H1B lottery, H1B registrations, and more recently, the multiple registrations, right? What is really happening is, for the past few years, since the lottery system started, the registration system started, a lot of people and employees and employers both are trying to maximize their chance, to make it H1B and be in the country and live the American dream. But the reality is a little bit different than what everybody aspires to be a part of. There are only 60,000 visas available for H1Bs and another additional 65,000, and then another 20,000 for people who have a US master's degree. And as you correctly said, Madhurima, the total is 85,000, but the number of applications or the registrations for the H1B being received are enormous, and as a result of that, the lottery system started where, everybody earlier would file their application, and USCIS would select the 100-ish, 100,000-ish, and then the rest would just have to be left. But then they started the registration process where they said, you don't have to file the H1B first. Send us a registration that you want to file. If your registration is picked, then you file, saving the employers the work and the cost hassle. But that's where we are, 2023, and the USCIS received well over 800,000 applications this year, which is like 10 times. So what's going to happen now? And that leaves many questions. Are there genuinely that many people that want to get these positions? Or what is the composition of these 800,000 applications that have been received? What do you think about it, Madhurima?
Yeah, especially I think that multiple registrations, we did see a part of it not so high as this year. We did see last year also multiple registrations. I think that what really made this year alarming, especially in last 2 weeks, right? Is having this 96,000 or 98,000, whatever those applications was done multiple with the collusion of the same or similar partners of the few technology companies or similar companies, I could say. I guess that's what it's alarming, right? And also what's make us more alarming from practitioner side is we did see lot of notes, obviously notice of intent to deny, notice of intent to revoke, which was filed last year, is coming out recently or coming out from the end of the last year. I guess, we did see that what is happening and what's going to happen this year. That's what the biggest alarming thing is. So the question is coming, I'm sure you're also getting the similar questions, is so what does it mean to the employers and what does it mean to the employees? So what do you think from employer side?
Yeah, no, absolutely. Let's step back a little and talk a little about multiple registrations. So there are various scenarios in where we can have multiple registrations. Sorry, I'm really battling allergies, so I'll keep doing this throughout. But what is multiple registrations? Multiple registration basically means one employee has filed for an H1B multiple times through different employers. Okay. Is that always a problem? Perhaps not. If I am a fresh graduate and I have 3 offers from 3 different companies and all of them want to file for my H1B, is that really a problem? What do you think, Madhurima?
I mean that if it is a legitimate offer, it shouldn't be a problem. So the question is, what is legitimate offer?
What's a legitimate offer? Legitimate offer is, again, I am an employee and I go, approach an employer, or I see an opening with an employer and say, hey, I want to be considered. And then they like my resume and they said, okay, we will, love to have you. But since you're a foreign national, you need an H1B, I'll file for you. Similarly, I go to an interview B where the same thing happens. And then I go to an interview C and the same thing happens. And maybe 2 of those 3 or all 3 of those employers want to file for me. Nothing wrong with it. It was a genuine situation. I went in genuinely with my genuine credentials. It's a genuine company. They have genuine work. It's a legitimate offer in that they really want to hire me. And they're completely unrelated companies. The A company doesn't know who B is and the B doesn't know who C is. And even if they know, they don't know that I'm working with them, and they file for me. Do you see a problem with that?
I don't see a problem at all when you have the legitimate offer, but the question a lot of clients has is, do we have to establish in a documentary with a job offer? How do we show that we have the legitimate job offer is the very frequent question.
And again, I mean, as different as the H1B world is from the real world, it's not that different at all. I mean, in a real world, how would you tell somebody that you have a job offer? You go back and you say, hey, here's my offer letter. They offered me a job. And similarly, H1B employers are supposed to be doing that too. Are they doing it or not is a separate question, for different various reasons. I mean, I'm not saying everybody is the same. Different companies work different ways. Different employers have different practices. And some don't have any practice at all, which is okay too, But ideally, a bona fide job, if I am a company who really wants to hire somebody, I will have some communication with that person, right? Yeah, here's the
Exactly.
job duties, this is your salary, this is where you're going to come, and these are your work hours, right?
At least a job opening, right? Posted somewhere, there is a position
Something.
available,
Yeah. There's some
obviously,
sort of communication by which I can establish that they wanted me to hire me. And that's it. It could be an email, it could be, a formal job offer letter, or it could be some sort of a confirmation or communication. But the problem is happening where, a lot of companies, or for example, let's say there is one person, one employer A. He has a company. And then he goes ahead and opens another company, let's say company B, same employer. Then he opens a company C. And the only reason he is opening these companies is because if he finds somebody that he finds attractive to, bring into the H1B pool, whether he is in the United States or many cases in, outside the United States, mostly India for our reference. Sorry. He will file for that person from company A. Then he will file for that person through company B. Then he will file for that same person through company C. All of these are his companies.
Yep.
This is a scenario which we are focusing on today. Is that right?
Yeah, the topic is right. Is that a right practice? No, obviously not. You're only thinking about how to game the whole thing, how to improve the chances for
Maximize,
your own company,
to
but
maximize
your
this
colleague.
person's chance, basically.
Exactly.
If he
Yeah.
doesn't get picked through company A, let him get through B or C. And
But
then
it is not fair to the system. You're changing
oh,
the whole system of it. It's not fair. Obviously, there is no jobs available for 800,000 applications when we all know that it's only 80,000 applications are there. And I know
right,
that in the Congress, we've been talking for the years that they want to change um,
the
the
numbers.
capacity
Mhm.
itself, but still, we are still at 80,000, and it's what, 800,000 applications. It's
Right.
not practically happening. And people are misusing the system, not everybody, again, right? So
Everybody.
there are the legitimate offers as we discussed about it. But
Mhm.
what we are focusing today is how these people are colluding, how they intentionally trying to game the system is what we need to do. And what kind of the charges, how do the employers, or let's go back, I guess, based on experience from the last year with all the intent to deny, intent to revoke,
Mhm.
based on that, how do you think, or what is the charges the employer will be facing it?
Right. So when these employers are submitting registration, they actually are signing, and they it's sort of an under oath. They're saying under the penalty of perjury, I attest that all of this is correct, and there's a genuine offer, and all of that, right? So you're basically
Yep.
telling them that you're doing this in good faith. You have a legitimate offer, in that all is good. I mean, and so basically what happens is when you're signing that, you are telling the government that this is true, but it's actually not true, right? And that's what the government is coming back after you for. They basically
Yep.
saying you attested and you signed under oath that whatever you're telling is true, but actually it's not. So what are the consequences? So
It's
what we are
criminal
saying
charges,
here, or your
obviously,
office
right?
is getting, I'm sorry.
Yeah, I mean that, especially when you say perjury,
Uh-huh.
it's a criminal charges, obviously.
Exactly. Right. So you're basically lying to the government, and that is, can get pretty serious pretty quickly. So,
Correct.
so what are we looking at, really? Has something happened? Perhaps it's not come out, but what we are seeing in real time, and our office gets a ton of these every day, and I'm sure it's the same story in your workplace. Lot of notices of intent to revoke. That's basically just saying, hey, we looked at your application, but we got 5 more with similar data, the same applicant or the same employer. And it seems like all of the companies that you registered through are colluding either under your flagship or people that you know and work very closely with. So basically,
Yep.
3 friends opened 3 different companies, and through those 3 different companies, they rotated like 90 people.
And
So
then
we
pretty deep in the investigation and the background check.
were
They're
saying
even telling the whole relationship, how this company
in the
and this
owners of the
partner
company.
and how
Mhm.
the familial relationship or the friendship or whatever, they're opening up everything, you
They are
really have
saying
to be
that.
careful. Yes.
Absolutely. I mean, I'm surprised without getting too much into the detail of a particular company. We got a notice last week wherein they're saying, sorry, Company A and B are owned by the same person. Company C is owned by the wife of the friend of this person. You know, I mean, they are not leaving any stone unturned in investigating this and going deep into who's related to whom. The office addresses are the same. The person who designed your website is the same,
Yeah.
and how come these same pool of 30 people are going through all of you?
Oh, yeah.
So it's
Yeah.
pretty slam dunk clear. I mean, it's not even, there's no room for doubt.
Right.
Any person looking at this will be able to make out there is some sort of a scheme here, right? Let alone total, like this is a whole made up scenario in which we are trying to see what to do to maximize these people's chances, but we're actually subjecting them and exposing your own company to various serious criminal consequences here.
And they're pretty serious about it, and I know that we only probably saw less than 5% of those noids last year, but definitely we should expect a lot of them this year, those things, and we'll tell the employees to be very, very cautious and make a right decision to see that right now you have a time until the June 30th, right? Obviously, you make a decision. If you are one of the person who knows that intentionally you signed those petition, or file the multiple registrations, think about twice before you even send that petition out, or the question also comes is, even they don't file the H1B, just by registering itself is a problem.
Yeah, they have had some exposure already,
Right.
but you can mitigate the damage further because
At least, yeah, exactly. That's what
this
it
is,
is, If you do know that you're one of that person, do think about it twice before you go ahead and file it. And by the way, the deadline is by June 30th, so yeah, I guess anything else in regarding to the multiple
again,
registrations?
just a little recap. If you think, so there are two parties here that we're addressing, right? One is the employer, one is the employees, right? We've talked about the employers. If you're an employer who has either on your own or in collusion with other companies or friends or partners done multiple registrations for a common set of people, it is time to rethink your strategy. It is time to rethink the security and safety of your company, as well as the future of those people that you're bringing in. Now, if you are an employee who is in this situation, and Madhurima, it's funny that we have people coming to our office who tell us, hey, I filed this H1 got approved. I was in India. I went for stamping. I got my stamping. I came to the US. I've been working for 4 months, and suddenly I get this notice that the USCIS now intends to revoke. And they are saying somebody else filed for me. I have no idea. Have you seen something like that?
Yeah, I don't have a personal experience with that, but I heard multiple scenarios with other colleagues with that. I think that sometimes the employers are just picking up randomly from this different career,
Career
I guess,
fairs,
the websites and other things, like, and just randomly filing it,
yeah,
and which the beneficiary has no idea that
I
somebody
know.
actually used it. And that's again the criminal act, obviously,
It is. It is. It's a
it's
lot of,
against the constitutional right.
there's a lot of problems. This is identity theft. This is, I mean, privacy, invasion of privacy. There's a lot of issues here. How can
Exactly.
you just find somebody's information and just do
Mhm.
it and then approach them? Now, that is where the question of a legitimate job offer comes to. Did you ever offer
Exactly.
them a job? Did you ever
Exactly.
even talk to them, interview them? Like, does it happen like that? So that's a problem.
And it
And
is a good practice to have that job offer letter. You don't, I mean, that you can obviously can be very small or bigger. The agreement can be in a different ways, but you can always put the terms like upon the request of the H1B, upon the
something.
immigration benefit and stuff like that.
Uh-huh.
But the thing is, it's a good practice in general to have that evidence as a part of the
As
future
part of the
notice.
whole candidate
Yeah.
file. I mean, for your security
Exactly.
first of all, and then obviously to protect your employee too.
Yep. And
There
also
could
the
be,
beneficiaries, making sure that beneficiary is also not getting in trouble with
right,
all these things.
right, exactly. I mean, there could very well be a situation where the both employer and the employee acted in good faith, but a
Mhm.
third party did something without the knowledge of these two. you
Exactly.
know and
Exactly.
if something like that has happened, I mean, there is defenses available. I don't want everybody to just run away scared from this whole thing. If you've done
Mhm.
nothing wrong, if you've done everything lawfully, if you've been abiding by the guidelines, there's nothing to fear. Even if something were to happen, come
Exactly.
talk to somebody, get advice from a professional. There
Yeah.
can be situations. We are in a very uncertain world right now, but that doesn't mean it's a lawless world.
Yeah.
The
The
law is
whole
good.
system is not a bad thing, but we just don't want to increase your opportunities by doing something illegitimate, So we're just encouraging the employers to be using the system as best and as right way they can, So which is the proper thing to do.
I mean, yeah, and then briefly, you said, what are the repercussions? The repercussions can be criminal. I mean, there's obviously obstruction of justice for many people that you're getting in their way. This is also visa fraud of a sort. So be careful. These things go a long way, and let's not think just short term for this year, 5 more employees. Let's think of your company, your own self, everything. Everything is at stake here. So
That's true. Again, June 30th is the deadline for whoever got selected. And if you have a legitimate offer and everything is fair enough, please go ahead and file by June 30th. And if there is something you need to double think or you need to discuss with your attorneys to see that if you are one of that employer by knowingly or not knowingly is involved in the multiple registrations, do discuss with your attorneys to see what is the best way to go forward, And by ending this subject, I think that the common question we're also getting is there is a second round of lottery? What do you think?
Yeah, I mean, I am hoping that there will be, and my hope basically stems from the fact that once they're able to eliminate multiple registrations, that's what they're doing now. Like if they find like somebody's clearly just engaging in a scheme to maximize their chance. I mean, I think they will go as far as just retracting all of those, and by that, I think more spots will open up. I mean, it's more than 100% multiple registrations this year. So which means
Yeah.
if half of them are already gone, then we're looking at 300 some left. We don't know. I mean, there is a chance there may be a second round. We will
But
don't
also the USA has also selected 115,000
correct. So
already,
it's
because out
over
of
and
the
above.
85,000. Yeah.
But I mean, most of the so my hunch also is because most of the people who have done something out of line here are not going to file those cases. So the
Right.
numbers
Yeah.
may be available, but we will see. We'll see come end of June and July, we will have a better picture. Yeah.
Anil, you have a
So,
question?
yeah. So,
We can hear you.
I think there's a technical issue in the audio. We can't hear you. If you want to type your question some way for us, then we'll be happy to take it. But again, for the audience, if you have any questions regarding multiple registrations, H1B lottery, everything that's current right now, please let us know. We'll be happy to take care of that. But Madhu, parallelly to this whole H1B situation and the registrations, we're also living in a very uncertain economic world right now, right? With the recession, everybody talking about unemployment, H1B tech industry, so many layoffs,
Of course. We did
unprecedented.
see that a lot during the holiday season. It started actually last year by October with all
Yes.
the MNCs layoffs, and I think that's the topic we're getting into the next, right? Yeah.
Right. I mean, you just briefly want to touch base into, a lot of these resources, especially in the tech sector, are H1B resources, right?
Mhm.
And unfortunately, or fortunately, I mean, we are in a world where they don't have much time, but everything at stake once
Mhm.
they hear the bell go, right? Back in the day, if you remember, if H1B resource lost their job, they didn't have anything like a grace period to leave the
Mhm.
country. They had to pack their bags overnight, sell everything, and just leave. A few
Correct.
years ago, USCIS started with what's called the 60-day grace period now. So if a H1B resource loses their job for some reason, they have 60 days to figure out alternate arrangements, which may include either finding another H1B employment, or if they want to go back to school, then going back on F1. If they need some more time to wind up their affairs, they can change their status to B1, B2. You have to sell your home, your child is completing school, things like that. And then in the meanwhile, if you can find something, you can do it. And if you find a H1B job, you can go back to H1B. But that's where we are. And what's your hunch on how things are going to be in the next couple of months? And if somebody were to find themselves in that situation, what do you think their opportunity or options are?
The first thing I do want to tell everybody is it is so good to have the 60-day grace period, but I do want you to look at the I-94 because if I-94 ends before the 60-day period, obviously I-94 is more valid than the 60-day
Great
period.
point.
Let's say that I-94 ends in the next 30 days and you do have 60-day period, but your I-94 ends, you have to take the I-94 as the priority.
Whichever.
So, I mean, well, I can't talk anything about the economy wise. I don't know how the world is going to be going towards it, but the layoffs thingy, obviously, I think that it's a continuation of what we saw during the holidays. You know, the biggest challenge and the question a lot of people has with the severance package, right? You know, they do say that you don't have to work for us, but we are going to give you the pay slips next 2 months or 3 months. You know,
Madam,
so
can
a
you hear
lot
me
of the
now?
Yes, we can hear
yes,
you.
we can hear you.
Okay, let me come. I mean, so we have a couple of questions from the audience on the multiple visas. Can we go ahead with that?
Yes, please.
Sure.
All right, 1 second. All right, there is a Gaurav Mujandar. Hi, good afternoon. My question is how to raise a concurrent visa and can my current employer restrict me to work under concurrent H1B?
This is not a multiple registration question. Yeah.
It's not a multiple registration question. Let's just take it anyway. So it's a question about concurrent H1B. What a concurrent H1B basically means you are on H1B already, but then another employer also wants to sponsor you for employment based. Can you do that? Yes, the law allows for it. Now, can your H1B employer restrict that? Legally, perhaps it's a gray area. You know, they do control your employment as far as that particular employment is concerned. Can they restrict you? I don't know what your employment agreement is like. You know, is there something in the employment agreement itself that's restricting you? If they ask you that you can't hold multiple offers, maybe that will come into play, and then we have to see how. But as far as law is concerned, if you legally on H1B and another employer is willing to do H1B for you, you can hold a concurrent employment with them.
There's one more question from Mr. Vijay. He says, my H1B visa was revoked due to my employer filed multiple filings after NOIR. Waiting for a revocation letter, not sure how many days I can stay in USA. Any legal advice for me? My employer not responded for NOIR allegation was related companies. So he's saying after revocation during grace period, can I stay in payroll until last day of grace period? And what are my rights when I am unaware of multiple filings on my behalf? How to prove my innocence?
Right. Unfortunately, thank you for a great question. Unfortunately, that is a situation many employees, finding themselves in. That's what Madhurima and I were just talking, right, Madhurima, where this employee is completely unaware. Now, this poor thing is completely unaware that another employer actually filed for him through either his company or a friend's company or something like that. If you are very certain, if you're very certain that you had no knowledge, and if once the investigation opens and nobody's going to find a document that you signed or a communication between you and the other party saying, yeah, go ahead, file for me for this company. If you're very sure, I mean, you have avenues. I encourage you to email us and let's discuss this case offline. But for general information, I would say if you are somebody that's innocent and has been caught in this trap of multiple registrations without your involvement, you have rights here. You can go after those employers for many different things. But first of all, again, be very sure that that's where you are, that you were completely innocent, you had no idea, somebody did it without your information, without your knowledge, without your consent. And if that's the case, then there may be remedies available, but do contact us offline.
Yeah.
All right.
And I think that he also has a question about the current status. Can he stay for longer?
Go ahead, Madhurima, you want to take that?
I think, it's only notice for intent to revoke. It's not the final denial copy yet, So once you have the final denial copy, I don't think so the real 60-day grace period really works at that point, because there is no status for you to use that 60 days grace period. But in the meantime, before you get the denial, you do want to reach out, as Sunila mentioned, to one of the attorneys to see that if you are a student already or you did had an OPT, and you end up selecting one of this H1B without knowledge, it got into the notice of intent to revoke, maybe there's a possibility of doing something about your status. But if you do get the denial, that means that you probably not have much chances to use the grace period.
Yeah, so it depends on what your status was. If it's a notice, again, just recapping what Madhuri had said, if it's a notice of intent to revoke, it's an intent to revoke. The revocation is not final yet. Sorry, the decision is not final yet. So you have some time to figure things out, but you got to act fast.
Yep.
All right, Madhurima, let's
Do
go
you have
back.
any more questions, Anil, or we can continue?
No, you guys can continue.
Okay. So I know one other question is there is so many processing. Do you want anything to wrap up on the layoffs?
Basically, no, just that. I mean, if you laid off and you were an H1B employee, what day controls? And, there are three things interplaying here: the severance package, the 60-day grace period, when does it start and end? And then one is, and Madhurima brought up a very fine tip about looking at your I-94. Even if you are laid off like today and your I-94 expires in a week, 60-day grace period does not hold. So if your I-94 is already expiring, that means you're almost at the end of your term anyway. If you've not filed an extension or if it's not been approved, then, the 60-day will not apply. Secondly, if you've been laid off and you've been given a 90-day severance period, for example, the layoff actually starts from the day you were laid off, not the 90th day of the severance package, because severance package is not the same thing as holding that job or that status.
Because there is no employer-employee relationship at that point. You don't have the work product going on. I know people like to comment, and there are the different attorneys are given a different way, saying that there are pay slips. They do show the employer-employee relationship, but you also have to think about other requirements, like actually, do you have the work requirement there? Are you holding a work product? These are all things that are also very important to make that decision.
Are you really working, or are you only getting paid? And are you actually getting paid? Or is it a severance that you were given because you lost the job? So those are the real-time questions. Great points, Madhurima. I think we can move on to the next section, unless, again, if there are any questions, please let us know. On 60-day grace period, multiple registrations, again, we're just wrapping things up as we move forward and, want to take
Well,
everything.
the processing times with the USCIS is still ridiculous, especially with all the 485 spending, EADs and travel documents, I guess. And the visa bulletin is not helping anything with the retrogression constantly from last few months.
Right.
So obviously there is ways you can get the EADs or even the AP, right? A travel document. If there is an emergency reason, or if there is a hardship and emergencies, that how to contact the USCIS and get these benefits. So what are the requirements when it comes to employment authorization? How can we prove that there is a hardship to receive the employment authorization either faster, or we can apply based on the hardship?
Great point here again. So what we are talking about is, let's say you've been laid off, and is there any way? And a lot of people, just like this other question we had, how do I stay in the country? How can I stay? How can I protect my status? What do I do? There is a little bit of a good news for people who are on H1B and have their I-140s approved already. Even if your dates are not current for filing the 485, even if your priority date is not current, but you have an I-140 approved and you've lost the H1B job, there may be ways you can get an employment authorization for 1 year if you meet certain requirements. It's called a hardship EAD. One of the requirements is either you or one of your dependents has very critical medical need. Children could be sick. They could have some situations which needs you to be here in this country so they can be taken care of. Otherwise, it's a severe financial hardship due to unforeseen circumstances. Something changed in your family, back home. There was some problem here with the employer and you retaliated. And as a result of that, you had to lose your job. There's other unseen. We're also looking at a lot of factors related to inflation right now in this time and day. And that has actually helped some people in overcoming this difficult time in their lives and getting the emergency EAD. So, but again, if there's, the key here is extreme hardship. Just losing the job is hard. I understand, and we understand that, but that alone is not the basis for getting the EAD. There has to be more extenuating factors. For example, medical needs, severe family circumstances, children.
Yeah, financial hardship is something it's hard to prove. But compelling circumstances, as you mentioned about the medical, life-threatening things, either to your spouses or to your kids, those things are something easily to be established because it's obviously a life-threatening situation and there is evidence to prove and all those kind of things, Financial hardship probably it's very hard for the USCIS to
not
accept
just
those
by
things.
itself. I mean,
Yes,
it's a financial hardship for anybody that loses a job, whether or not H1B. So that's already hard, and not undermining that, but that alone is not the basis for this new benefit. The bar is higher. They need more than just the financial hardship. It has to be critical, it has to be family related, it has to be life related. But again, if you are in that situation, the determination is made on a case by case basis. USCIS looks at every case differently. There is no one rule that fits all situations. So if you have something like that, please contact an attorney, and I'm certain they'll be able to guide you with what's best for your case.
Yep. I think that the last question, right? Okay, a lot of people applied for the H1B. The same people got 10, 20 applications got picked, and I didn't even got picked one H1B. What should I do now? I mean, obviously, if you are here as a student and you still have the OPT, please do continue to use, right? And if you finished your OPT, you may want to think about it, doing something more higher studies and try to get on the F1 again, or if your spouse do have existing work visa or something, maybe you want to be dependent, or if you do want to work, and what other options are there? Sunila.
Great question, Madhurima, again. There is one particular resource in one particular area that very few people look into in the H1B world. That is called H1B through non-profits. While H1B is mostly used by the for-profit industry, there are a lot of non-profits in the tech sector, hospitals, research organizations, other government bodies that also do H1Bs for technical people, but they are non-profits. Or
education institutes are one of the top most, actually, universities.
Absolutely. Universities, again, and hospitals, and and these could also, the interesting thing is, these could also be for-profit institutes. They're working for a non-profit, and then they will employ these resources in those positions with those companies or those hospitals or those organizations or those universities. So for example, as students, when we go to these schools, all of these schools have something called an entrepreneur program in their business school, or they have a career cell. Those places also have employment opportunities for students, and those are all exempt organizations. Exempt meaning they don't have to go through the cap. So if you were somebody that went through the H1B cap but not picked, and then you still are here and you want to get into the program, or you want to get employed with one of these entities can do your H1B too. So look at the nonprofits, and again, nonprofits are not just some self-help centers and things like that. I mean, those are all great organizations for a cause, but there are other organizations, again, like I said, that can do a nonprofit. And the good thing is, if you are working part-time for a nonprofit, for example, if you're working 20 hours a week for a nonprofit, you can do a concurrent for-profit H1B and work in your regular tech industry. So for example, if a hospital has a database position, again, database entry, or a data science engineer, or somebody work on their hardwares or in their network space, or as a business analyst, or control their reporting tools, whatever, different technical positions, there could be so many of those. If they were to hire you just part-time for 20 hours, based on that H1B, which is a non-profit, you could approach a for-profit or a regular IT employer if they have a position, and they can hire you in parallel for up to a full-time position too, like 35, 40 hours if you can carry off the load for 60 hours, that is, but you can do it. So that's an opportunity not many people know, but I encourage people to look into those things.
And also, they can be applied anytime during the year. They don't have to wait for April, October, whatever this the regular cap kind of things, you know. And we done this non-profit H1Bs, even for the smaller non-profits, you know, as long as they're connected to one of these existing educational institutions, health resources, or anything like that. There's a list of the employers who are cap exempted. When we say cap exempt, they are not actually the H1B cap exempt. The employer is the cap exempt here. So you need to look at it, who comes under the as an employer cap exempt. Most of them are educational institutions and like a universities or the schools, and also a lot of health related and the research and the army, going, all those kind of related things. But you don't have to be in that bigger institute. As long as that nonprofit is connected to that bigger institute, or the purpose of that employer cap exempt thing, you're still eligible to file this. And it is a great source. I know you're right. You know, a lot of people don't use it. And even the employers are not aware of it, that they can able to hire these people on this basis, you know?
Yeah. But,
that's,
you know, so that, and then there, you know, also depending on your nationality, if you're, another country, I mean, there's like options like E2, you know, there's options like E3, there is TN, there's H1B1, depending on where the individual is from. Singapore and Chile nationals, for example, you know, it can do the H1B1, and then Australians can come in on E3, Canadians and Mexicans can come in on TN, and things like that. And, you know,
a lot of people may be working for the same employer outside the country, you know, and if you didn't get picked in the H1, maybe look into the L1, you know. It's not, people think that L1 is only meant for the MNCs, you know, that's the other thing, you know. So L1B can be done for the smaller companies. There is no restrictions or the requirements for it, you know. And we've been doing this from last 10 years. Actually, most of them are the smallest companies, the employees who are less than 25, you know. And just because it was used by blanket L1 with the larger companies, it doesn't mean that you are not eligible for the individual L1B. For any kind of the company could do that. And which is I do encourage that one, because that's the other good route to stay longer, and also maybe possibility of changing to L1A, EB1C. There is all good options, you know, you could always think into those kind of things.
And a faster green card there, right?
Oh yeah, exactly.
Ultimately, that's the goal for most of these people. So yeah, explore options, you know, don't give up. H1B is not the end of the world. It's a great way. It's a great path to be on. But if you don't make it, that's not the only way, you know, so there are options. So again, I encourage you to, you know, get advice, spend that time, spend that money talking to a qualified attorney, and get your options correct. I think it's worth it.
Yep. So Anil, do we have any questions? Not sure. Okay.
All right, then, you know, just wrapping thoughts. Basically, again, end of the H1B, we're going to get
Before we wrap up, and Sunil, I want to pick on something. So how is the situations with the 221Gs at consulate?
I wish I had a good answer.
I know it's a big topic, but just wanted to touch base. Do we see reduction in the 221Gs, or how is it going?
For the past few months, we've not seen as many as we did in last fall and winter. You know, it could also just be because not many people are going now, because all of the ones that, you know, had their lotteries picked last year prior to October went, and that's why we saw a whole influx of those kind of things. And it has tapered down for multiple reasons. I mean, you know, there have been a few rulings, you know, against USCIS. The whole client letter, vendor letter requirement have been shot. So even consulates who were still asking for those documents despite the rulings are now being, you know, given a hard time by the government. There is a lot of federal litigation in this area as well. A lot of the consulate decisions are being challenged in the US federal courts, as a result of which these consulates have had to come back within the specified timeline and issue decisions. and can't act as arbitrarily as they have been in the past. So a lot of things, I mean, I think a reduction of those kind of cases itself, the new rulings and, better and improved light of law has all helped in kind of at least for us seeing those kind of things reducing a little bit. Have they gone away completely? No. I also see that the wait times are getting a little bit better. More appointments are becoming available now as compared to last year, where we were waiting like, 2 years and then had to go to a third country for stamping and things like that. So not seeing it as crazy now, but what has been your experience?
I did see the reduction in the 221Gs for sure, but I'm also seeing the weirdest things sometimes, So especially the people who got picked a couple of years ago for the lottery, right? But they couldn't able to go either because the dates are not available or because the work is not available or the employer is not ready to bring them right away. We do see that 221Gs with saying that are they still working with the same client? Is there any changes? Things like that, we do encourage the employers to file the H1B amendment if there is a changes, obviously, things like that. But there's definitely reduction of the issuance of the 221Gs for sure, But I don't think so it's completely gone away, but we still receive them, but definitely a shift in those numbers, which is a good thing. Yeah. Let's
Great.
wrap up on this, and I guess as regards to the multiple registrations, I mean that the system itself was good, but somehow it ended up having the recorded number and multiple registration collusion and all those kind of things really made to start thinking about it. And again, the deadline to file who got selected is June 30th. If you do have a valid job offer, please go ahead and apply. You don't have to worry. Not everybody has to be concerned about this thing. But if you do have a concern and if you know that by knowingly, not knowingly, you're involved in the multiple registrations, please do talk to the attorneys, to see that that's something you wanted to go forward or no. As Sunila and me, we both agreed that, yes, knowingly you did the registration and you've done some damage, but you can control the rest of it, So that's my takeaway. Utah.
No, I agree. I think you summed it up beautifully. Again, it's an unpredictable world. And I think the first thing we need to watch out is for your own security, your own safety. If you're a company, then your company's safety and your future as well. Let's not be pound foolish and penny wise and pound foolish. That's what they say. Let's not think short term. Let's not think of this year. There is lives involved here. And let's be compliant. Let's be ethical. Let's build our businesses ethically. And that's the way to go.
And let's save the system, right? And I know that we all agree that 90% of H1Bs was used by most of the Indian nations. It's our community. We grow as a community. We develop economy in this country. Let's keep as long as it is. I mean that just because we play multiple, it doesn't mean that you're going to have multiple offers. The valid offer is very, very important. How you practice your business also has to be rethink, and it's a good practice for the future.
Absolutely.
And the 60-day layoff thingy. Most important things is look into your I-94, look into your severance package, and play around the 60-day grace period.
And see what your options are. Do you have a spouse? Do you have family? Do you have other ways? You want to go become a student again? Things like that. Whatever you do, again, do not
fall. Hardship waiver, even though you don't have the AOS pending, which is adjustment of status, and just you have the I-140 approval with your H1B laid off, we can think about having applying the EAD with the hardship, but it is very, very hard and very high bar for this to get into that, but if you do have somebody who is going the compelling circumstances and you can able to prove it, you can definitely try it. Absolutely. And I guess that's all.
Yeah, and the last not the least, H1B is not the end of the world. Look at other options. There are other ways to get in here. Stay compliant, do not fall out of your status, do things right, pay your taxes, be compliant with the law, and things work out eventually.
And non-profit is a great idea to do it as a option. Yeah.
Right.
Well, I'm thinking that it is a productive webinar. And Atta
Thank you very much.
A lot of these things.
Thank you very much, Madhurima Garu. It means a lot for ATA community for coming up and giving your suggestions and enlightening the ATA community over here. And it means a lot for ATA. And a couple of people asking for your contacts so that they can contact you guys offline. So if you guys want to tell your phone number or email ID, it is okay.
I encourage them to go to our websites, paturilaw.com and somireddylaw.com, I guess, Sunila, is that your
Yes,
website?
that's correct. And my email is info@somireddylaw.com, and Madhurima, I can give yours if you want.
Madhu@paturilaw.com.
Yeah, the previous question Vijay asked, like, it looks like his I-129 is already revoked.
Already revoked.
It's
Yeah,
finalized.
unfortunately, there's no other.
Yeah, there's another guy also asking the same question, Mr. Ramesh, and he's also in the same revocation, and he got revoked already. Now still he's asking.
And this is a great questions, and these are realistic questions, none of the beneficiaries thought about it, and which is a great thing. I'm glad they're coming and talking about it, which is very, very important. And this is why the new selections needs to rethink before they file the petitions.
All right. All right. Once again, thank you very much, Madhurima Garu. And Madhurima Garu is our legal chair for ATA, as well as Sunila Garu from Somireddy Law representing. So thank you very much for your time. And Dr. Eramreddy Tirupati Reddy, our Joint Secretary, for giving an opening note. And all ABR crew, Mr. Naveen and all other technical crew, thank you very much on behalf of ATA. And I appreciate our President Madhu Bomineni Garu and the Executive Committee for initiating these type of shows for the sake of ATA community to enlighten them. Thank you very much.